Welcome to all. We have with Laura Zoboli the pleasure to introduce a panel on the European Commission project proposal, in fact, of Digital Markets Act. You will have the pleasure to have with us four outstanding panelists. Two from the academic sphere, Simonetta Vezzoso from the Université di Trento, Alexandre de Streel from Université de Namur in Belgium, and on the side of practitioner and the side of authority, first an horizontal authority, the Italian Antitrust Authority, with Alessandra Tonazzi, and second, a vertical regulatory authority, the French one in the field of telecommunications, with Chiara Caccinelli. So Chiara, Simonetta, Alessandra, and Alexandre, again, thanks for being available today. In fact, today it is a real hybrid session, because we are currently at Würzburg in the framework of a German-French symposium on competition policy and digital markets. So we have here with us some colleagues like David Bosco from the University of Aix-Marseille, Florian Bean from the University of Würzburg. So the people in the room, in the real life, in fact, will also interact by using the chat available on the YouTube channel of the Brazilian Center of Innovation and Competition. Before presenting our session, I have to warmly thank Eduardo Gaban and Vinicius Klein, which were the guys behind the screen and behind the whole organization of all this symposium. It's a great honor for me and for Laura to be a member of the advisory board of the IBCI and to have the opportunity to organize this session. So, some words in order to present this session. Last December, the 15th of December, the European Commission proposed two different texts. The first one called the Digital Services Act, and the second one, which is at the center of our today's discussion, is the Digital Markets Act. So, before presenting the three successive rounds of this round table, I will make some very general comments for Brazilian and European colleagues about some basics of this DMA proposal. First, if you allow me to make an historical comparison, in fact, there is something which is parallel, which is coherent between our current DMA and the old US Sherman Act. If we consider the situation in the US in 1890, when the Sherman Act was proposed to the Senate and eventually promulgated, the only thing that the US legislator knows was something has to be done with the trust. That is to say, we have a problem of concentration of economic power, and you need to respond, you need to find a solution to meet something like a social concern about this trust. The concern there was not a concern in terms of efficiency, mainly, but a concern in terms of a competitive process. The risk to make the American economy less and less competitive, with less opportunity to enter the market, and in addition, less opportunity to compete fairly on the market. So, at the difference of Robert Bork, we can say, okay, efficiency was only one of the points of the Chairman Act, but never, in any case, a consumer welfare prescription. That is to say, it was first preserving the market and preserving the opportunity on the market, and after, perhaps, efficiency. It is perhaps one of the main points of comparison. We can make a second one. When the drafter prepared the Chairman Act, they tried to think, to find solutions with the resources, the legal resources provided by the American common law. In fact, if we consider the Section 1 and the Section 2 of the Chairman Act, it was an attempt to make this legislation coherent with the current legal standard in the state. And we will see that, roughly speaking, the same may apply for the DMA. First, the DMA arrives at a moment in which we can have joked about the capacity to address the difficulties induced by the concentration and the big tech. I made perhaps a short stop because one of my, several of my colleagues, I think all my colleagues here, have some difficulties to access to the IBCI channel on YouTube. Laura, can you share with us
yes,
on the comments?
Of course, I am also on YouTube and everything is working
yes,
well.
If you can write the link towards the IBC channel on YouTube, we can connect. So if I may, I will go on. So the question is the following: can we address the difficulties raised by big tech with current competition law? That is to say, with the Article 102 of the Treaty on the Functioning of the European Union. We have a lot of difficulties, mainly the excessive long durations of procedure. If we think about the Google Shopping case, we started in 2010. We have the decision in 2017, and certainly tomorrow we will have some news about the General Court. The second limit is the cost induced by the effect-based approach, the contradictory procedures under current competition law. This effect-based approach is only difficult to implement because of the risk, possible risk of false positive. Second point, fines may be insufficient to deter anti-competitive practice. Perhaps, if I may make, if I can draw a parallel with the case of negotiated procedure, I think to the US, the Judge Rakoff said about financial activities that a consent decree or plea bargaining can be the cost of doing business. Perhaps in our field, a fine can be the cost to acquire a monopoly. So, how to prevent a definitive harm to competition through a current antitrust law if we have not some restorative remedies. That is to say, if we cannot the harm to the market. we have a lot of tools. Some of them are not enough used. For instance, interim measure, corrective interim measure in antitrust matters, but some other, like behavioral remedies, can be difficult to implement. Why? First, because of adverse selection issue, how to define, how to design, how to craft proper remedies first, and second, because of difficulties induced by moral hazard. That is to say, how to be sure of the proper enforcement of remedies. Finally, we have something we can discuss on this, which are structural remedies, and we can see if such structural remedies are a myth, something that we cannot use, that we cannot apply here, or if such structural remedies can be a solution. If there are a solution, what will be the cost in terms of efficiency? So, if we have a problem in terms of competitive harm prevention, if we have a problem in terms of remedies, in terms of deterrence, how to avoid a tipping of digital market toward a situation of dominance and possibly a situation of irreversible dominance. And second question, how to ensure a fair competition on the market. Fair competition not defined in terms of distributive justice, but fair competition defined in terms of the absence of distortion or the royalty on the marketplace. In fact, the DMA can be conceived under this prism. We can discuss this point. The DMA try to ensure the contestability of the market, that is to say, the free access of the market and the capacity to challenge existing dominant position. And in the second time, the DMA try to ensure the existence, the permanence of an undistorted competition. We can find a way to define a fairness like the guarantee of the absence of distortion on the marketplace. Absence of distortion, it can echo competitive concerns like self-referencing, for instance. But the DMA has several specificities. First, the DMA would be used only for gatekeepers. That is to say, firms that control the access to the market for others and that can play as private regulator in their ecosystem. So a first question here can be what is a gatekeeper and how to properly define the scope of this notion. Second characteristic of the DMA, it's Article 5 and Article 6 that are based on per se rules. That is to say, it is not the implementation of case-by-case analysis through a contradictory procedures under a rule of reason based on an ex post assessment of the effects. If I may take the point of David Bosco this morning here in Würzburg, it is a case of modernization of competition law, like we lived 20 years ago with a more economic approach, but something like a post-modernization, again, the word was coined by David, in which we come back to a per se approach. What are the merits? What are the risks? such an approach. Finally, if we take our DMA, we can wonder to what extent the tools provided by the DMA can be effective to preserve the competition and to ensure, in fact, a future competition on the market. That is to say, are regulatory types tools like data portability, interoperability would be sufficient to limit switching cost, to limit the risk to see consumer or trading partners captive from a given ecosystem, that is to say, to restore both contestability and to some extent fairness, how to limit the risk of self-preferencing. Should we ban self-preferencing or assess it on a case-by-case basis? And finally, what could be the way to address situations in which the market process is irremediably limited? That is to say, what to do after the tipping. May structural remedies be effective and possible to implement? If we remember, in June 2020, when we had the preliminary impact assessment, or the inception impact assessment of the DMA, we spoke about a new competition tool. And this new competition tool, inspired by the UK practice with market inquiries like they are implemented since now, I do not know, 15 years, something like that in UK, can be made to unblock the competition. So it is the general points that we can see today with three different rounds of discussion. The first one will be devoted to define more precisely, more accurately, what are the main proposals included within the DMA, and to see where we are now, 11 months after the proposal of the European Commission. Second, we will try to discuss and to assess to some extent the scope and the legal tools proposed by this DMA. And finally, we may address some institutional dimensions regarding the enforcement of the DMA. What is the proper level of implementation of the DMA? European one, member state one, who is the best regulator to implement this DMA? So 3 rounds and 4 colleagues to address these questions, and all the colleagues present here in Würzburg, in Brazil, or only online. So do not hesitate to use the question and answer on YouTube, and we can now pass immediately to the first one, a question devoted to the presentation of the DMA and the definition to the point where we have now in November 2021. So perhaps to start, Alexandre, do you want to take the mic at first?
Yes, thank you very much, Frederic, Laura, and all the organizer for this discussion. I mean, the DMA is an important text, as you have mentioned, for Europe and possibly beyond, because every region of the world now is thinking about regulation, regulating big tech. And so the DMA is one model, and is probably one of the most advanced model in the sense of it is really about to be adopted. My feeling is that the text you have proposed, that you have explained, that the text that the Commission proposed and that you have explained will be adopted relatively soon. There is an intention to adopt this text by the summer next year, summer 2022, and then it will enter into force 6 months after. So we may expect that this new law will be in force in Europe at the beginning of 2023. And from what I have seen in the negotiations so far, but the other panelists are also following that very closely, we will meet that deadline, and the text will not change radically compared to what the Commission has proposed. So contrary to, I'm not sitting in the US, you know, and you have a lot of bills which are proposed in the US Congress, but, you know, it's everyone guess if anyone will pass, you know. So it's very different. I mean, people have to understand that the European process is working to some extent, and so we will have the DMA, and I guess not so far from what the Commission has proposed. I want just to make 2 points about this DMA in general, and then we will, as Fred you were saying, we will develop some of them. The first point I want to make is that this is clearly a revolution, but it is based on European tradition. And I think it's important to see that. So it's a revolution because it's the first time that in Europe we will have a law which is targeting only the big tech. You know, the law, the platform law that we have in Europe tends to be so far symmetric. You know, for instance, we have the GDPR, the General Data Protection Regulation. This is applicable to every platform, big and small. We have we had a revision of our media law some time ago, which is now targeting what's called video sharing platform. But again, this is targeting big and small. You know, we had a platform to business regulation, which has been adopted 2 years ago. Again, this is symmetric. So, you know, it's the first time that we have a law which is targeting big tech. And I think that's right, because that's where we have some specific problem, you know, and we will alleviate a kind of perverse effect that some authors have shown now that the GDPR had, in the sense that by being symmetric, in a way, it is more costly for the smaller player than for the bigger player, and therefore it has a sort of anti-competitive effect. Okay, so in that sense, it is a revolution. But on the other hand, if you look at the text, as Fred has presented very clearly, it's based on European tradition. And let me show that for 5 elements, the 5 main elements of the text. If we take the objective, now, I would agree that the objective is not extremely clear. The objective is talking about contestability, market contestability, and fairness. But, you know, it's everyone guess what exactly contestability means and what fairness means, as Frederic has mentioned before. But I think the implicit objective behind, and some amendment in the parliament are pushing to make it more explicit, it is to push innovation in Europe and in the digital economy. Okay, so that's really at the end of the day the objective. And how the DMA is wanting to do that is by opening every path of innovation, to be sure that if you are an innovator in a garage or everyone else, you can indeed enter in the market. And that's really, I think, what the DMA is about. So basically, it is helping the people who do sustaining innovation. So for instance, the user of the platform, the business user of the platform, which keep the platform but innovate on it. I mean, it will be easier for them with the DMA, for instance, because there are some access obligation to the platform and interoperability obligation which are there. So, you know, the sustaining innovation on the platform will be support, and also the disruptor, you know, because as we know, I mean, innovation happen in those sectors, not so much with frontal competition. So it would be foolish to expect a new Facebook or a new Google search. But what you need to have, what you need to push and open the path to, is for someone coming with a new product, but can connect if you want, with the ecosystem of the existing platform. I think that is really the objective of the DMA, and it managed to do that to some extent with the obligation. So I agree with some commentators which have been very critical towards the DMA, that it's not very clearly expressed, but it is there, you know, and it could be used by the Commission as an enforcer as a way to promote innovation. And you know, because many people ask, but what will be the criteria of success of the DMA, you know? And the criteria of success of the DMA, I think, will be whether we have more innovation in the digital sector. Now, the second thing, and you know, that is traditional, because if you come back to the Microsoft case in Europe, you know, that was exactly that, you know, it was to open the Microsoft platform to be sure that Sun Microsystem in that case or other players could innovate. So I think, you know, we are very much in line to what we have done in Microsoft in Europe. The second tradition, I would say traditional choice, is that you use regulation as a complement to antitrust. And there, Fred, I will slightly disagree with you. I don't read the DMA as a way of coming back to the pre-modernization period, where in antitrust we were using a per se rule, because we are not in antitrust. I mean, we are in regulation, you know, and that's very different. So that do not mean that antitrust will come back to per se rule. I mean, that means that regulation has chosen a per se rule path. And as I will explain in the second panel, I think it makes sense, you know, when you are at the very beginning of a new instrument, it's maybe better to have very detailed rule because they are easier to enforce than to have overall general standard. And again, that's not new. If you follow the evolution of telecom regulation in Europe, you know, if you go back to the 97 directive, which was one of the first liberalization directive, in fact, one of the first regulation after the liberalization, it was very much based on per se rule. You know, you had interconnection, which was imposed. You had market which were predefined in the in the directive. You were regulated if you are 25% of this predefined market. So, you know, we were very much in a rigid system. And then as we get along and as the regulator become better, we move to a system which is more flexible and standard-based. But so, and in fact, if you read the evolution of competition, it was the same as you have described. We went from per se rule, but as we gain experience, we go to standard. So I think it's a very traditional, let's say, path of evolution, and it's not really putting into question the modernization. The fourth element is on remedy. And here again, we are very traditional, because if you think generally, and we will discuss the remedy in more detail later, but really the goal of the DMA is to open the platform, not to break them up. Of course, there is a breakup possibility if you don't respect the opening obligation, but that's not the objective. So, no, so it's contrary to what, for instance, the FTC in the US wants to do with Facebook. The point is not to break those platforms up, it's just to open them up. And again, that's exactly what we have done in telecom. When the liberalization was decided, it was not said, okay, we will separate the telecom players between their wholesale activities and their retail activities, but it was decided to open them up. And there was this open network provision program, which allows the competitor to build, to rent the existing network and to build their services on that. Again, same logic. The only, if you want, new choice which is made here, and which is very important, is that it will be the Commission which will be in charge of the enforcement and not the national regulatory authority. So that is very new, and we should not underestimate this innovation even for the European construction in general. Because for the first time in the European history, we will have the European Commission, which will become a regulator for the first time. And so for the first time in European history, we will have a concurrent regulator at the European level, which is the European Commission, which will have antitrust power and regulatory power. Very new rule, new role for the Commission, and it will, I guess, not be without any issue. So, you know, my first point and the second point, rest assured, it will be shorter, but that yes, it is a revolution, but it's a revolution based on very traditional European choices. Now, the second point, and that is related to the implementation, is that, of course, as we say, the proof is in the pudding. So here, in a way, the proof will be in the implementation, not so much in the intention of the rule, because sometimes when you hear some debate in the European Parliament, you think that those people are very ambitious, but I'm not sure that they will get the means of their ambition. So the proof will be in the not so much in the intention, not even in the rule, but in the implementation. So for me, the adoption of the DMA is just the first step, and if you want, the easy step. All the difficulty will be to implement that, and it will be particularly complicated. Why? Because although the rules are detailed, and as I said, I think it may be a good choice, they will not, contrary to what the Commission thinks, be self-enforcing. There is this idea that this text will be self-enforced because the rules are so detailed. Maybe some rule, in particular prohibition, will be self-enforceable, but others, like everything which relates to obligation, access to platform, interoperability, data portability. How can you think even that it's self-enforceable? I mean, it's impossible. I mean, it will be very, very complicated to do. So I think on that, the Commission seems to be a little bit overconfident. It will be also complicated because it's a new role for the Commission. As I told you, I mean, the Commission has no tradition of being a regulator. And as Chiara will explain to us, it's not easy to be a regulator, not easy at all. In particular, in a sector like digital, which is extremely fluid, which evolve very quickly and is often unpredictable. So, I think the DMA as such is a very good basis, but my main worry is that the Commission completely underestimated the difficulty of enforcement, and that at the end of the day, it will not work as well as we hope for. And so what is very important is that the Commission partner with everyone. So, I mean, the National Regulatory Authority, the National Competition Authority, the stakeholders, the civil society, us, the academics, and so on, to try to, and also authorities across the world. So Brazilian authority, of course, US authority, and so on, to try to make the best of it. Because, we should not underestimate the enforcement difficulty of this text. Thank you very much.
Thanks, Alexandre, for all these points, and thanks for placing several of the DMA proposal within a very long tradition in EU competition law. You quoted Microsoft. We had the concern in Microsoft with the protection of subsequent innovation. That is to say, how to preserve innovation within the market when the market can be an ecosystem. So, and you insist very accurately on the difficulty of implementing the legal resources provided by the DMA. So we can skip from Belgium to Trento Adige with Simonetta. Simonetta, your views on both on the objectives of the DMA and on the possibility to implement it properly in the given situation, in the situation of the day.
So thank you so much, Frederic, Laura, for the invitation. It's great being here. I just got a notice from Zoom that my internet connection is not very stable. Can you hear me properly? It's okay for the time being? Okay.
We can hear you.
Okay, thank you. So thank you for the invitation. Well, first of all, perhaps, as you said, Frederic, going back these last 11 months, basically, from the 15th of December.
Simonetta, we have a little break in your connection.
Yeah, I was a little bit worried about it.
Yes, it's okay now. It's okay now.
Okay, so the 11 months since the DMA proposal was tabled have been very exciting, because we have been finally discussing the type of digital economy we would like to live in. I think it has been very also fascinating following the discussions at the European Parliament, because they are open discussions and different proposals, and then there are different things put onto the table. So I think from that perspective, the fact that we have the DMA proposal is a very good thing, because we really needed to have that discussion. The thing is, the discussion came after the proposal itself. So we are faced with what is it? So is it regulation? Is it competition plus? So somehow for us academics, it's a very exciting time, because of course we are catching up as usual, but it's really, it's a matter also now, once we have it in place, it's a matter also of enforcing it, interpreting it properly. So what, as Alexandre has already been saying, what are the objectives of the DMA, because that would be very important from the point of view of the interpretation of the different obligations. So from that perspective, I think there is much work to do, and it's much work in progress. As I said, I think it's a pity we didn't have the discussion beforehand. We were too much focused on the need to tame big tech, which is of course our task here. But I think we need to go a little bit beyond that and think what type of digital economy, okay, we would like to have in the future. So that would be my first point. And that brings me to my second point. That would be, we shouldn't be considering DMA in isolation, because I think it's a part of a broader digital strategy by the European Commission. And that's an important, you see it very clearly with regard to data, because there are quite a lot of other data-related initiatives going on, but you see it really in different bits and pieces of the legislative framework, which is changing. So I think it's very important we see the DMA also as part of it. That makes the DMA perhaps less exportable as the GDPR, General Data Protection Regulation, because I think the DMA makes sense as part of the general digital strategy. In other countries, perhaps it wouldn't be a good idea to have anything like the DMA, since we are now talking here in front of the digital audience. Because, for instance, interesting things are coming from South Korea, just passing legislation on some issues with digital payments related to app stores. So other jurisdictions could decide to go another way, and that would be perfectly fine. In South Korea, of course, it's interesting to Chiara, I think, basically, I mean, to all of us, but it's a telecom legislator, which is enforcing that South Korean legislation, which is also quite interesting, considering things that are moving. So so we have it on the table. We are trying to understand it to make it work. But I think the European Parliament has done actually very good work in improving it. There have been interesting changes. Perhaps we will go back to that later. So I'm not convinced it's the best possible tool available to tame big tech. You were mentioning the new competition tool, which has disappeared. So I think we would need also tools like that at the European level as well. But we have it on the table and discuss it. Thank you.
Thanks, Simonetta. Perhaps directly the view of enforcers, first the competition authority, and after the telecommunication authority. So we skip from Trento to Roma. Alessandra, what are your views about first the tool and second this issue of implementation?
Thank you very much, Fred. And first of all, thank to you and Laura for inviting me here. And as representing an authority, the usual disclaimer that what I'm saying here doesn't represent the official position of the Italian Competition Authority or any European work, but just my own, although they are very much reflect the discussion that we've been having. Well, what are my views? First of all, you started a bit your presentation from the proposal on the December 15th until now, these last 11 months. But I think we started this discussion, at least as competition authorities, much earlier. In fact, and rightly so, I think, in the last at least 3 years, we have been discussing with respect to the digital economy, and in particular to the role of big digital platforms, whether the tools that we had were enough, whether we needed to make significant changes to competition law enforcement. And you have already mentioned this. We started the discussion on new legislation, and on the table we had this new competition tool that we discussed for several months. So it's not just something that appeared for a short time. And this reflected a discussion where, as competition enforcers, we were trying to identify where we had an enforcement gap with respect to digital platforms. So we had some tools. We in several official occasions and unofficial occasions as well, competition authorities always said, the tools that we have are useful. The tools that we have, we can use them. And in fact, we've seen a lot of cases involving big digital platforms. As you said at the beginning, and also Alexander, the European tradition very much allowed competition authorities to address issues such as the competitive process. We were, with respect, for example, to the US approach, we had a much wider view in applying competition law. So we had this that we could also use with respect to the digital economy, but we identified that there were problems, and I'm just saying some of them. For example, when assessing market power, or the traditional framework of analysis that we use to address market powers sometimes was not good enough for the digital platforms, especially you've mentioned in terms of the fact that we have this phenomenon of tipping markets. So that you can very quickly go from a very small market share to having a market where it's difficult for competitors to enter. Another issues that we addressed were killing acquisitions with respect to mergers, and whether our merger review system would allow to face that. We also, this has completely disappeared from the discussion, but I would like to mention it today with respect to collusion and algorithms used to facilitate collusion. This is, all these issues, in my opinion, an instrument like the new competition tool probably would have been able to address many of these problems. And beside merger review on another, it's also a missing part of what we are discussing today with the DSA. But the DSA, as you rightly said, it's there now. It's as Alexander said, it's proceeding rather speedily. We'll probably have it next year. So what we think? I think there are a couple of concerns that we have. Although we think it will be an additional instrument, it will be complementary to what competition authorities are already doing. And one, maybe we'll talk in the next session a bit on how the design of the conduct that are prohibited or the obligations. There is some concern on how this, so this is regulation and this is fine. It's not the competition authorities are against regulation, but when you do regulation, especially if you're doing new regulation, maybe you should reflect on how well sound are the conduct that you are addressing. And in this case, sometimes this conduct is based on cases that are still ongoing. So some of this we see as a problem. The other is, I'm not as enthusiastic as Simonetta on the discussion that is taking place in the Parliament. Because what I am afraid is that sometimes in this discussion about the DMA, the fact that it went in parallel with the DSA didn't help very much, because with the DMA, we are clearly trying, the Commission is clearly trying to address some market problems. With the DSA, we are addressing other problems which are equally important, but sometimes in the tendency that we see now in the Parliament to add new conduct, new problems, even new addressee of the regulation, there is a risk that we'll have a very broad instrument, but then with the concern on implementation, I will say something later in the institutional framework that I share with Alexandre. We might have a tool, but then it might be difficult to implement it. Thanks.
Thanks, Alexandra. Among the different points you mentioned, and that makes perhaps the DMA a little bit incomplete, despite its inherent complexity, is the absence of provisions regarding mergers. And I remember a joint position of Dutch, German, and French governments last spring on this point. And another point you mentioned, which is very important, is a lack of consideration in the DMA for algorithm-related issues regarding manipulations, but perhaps risk of collusions and so on. So these points, I think, could be relevant in our discussion. And there is another point you mentioned at the start of your intervention, is the interplay between regulation and competition. And it is very important here to insist on the fact that in the US and in the European Union, we have some very different way to articulate these two dimensions. That is to say, antitrust applies even if we are in regulated markets. So it is very specific when we consider other institutional regimes. But the transition is quite natural through Chiara. Chiara, I think, is currently in Paris. So Chiara is here both not a representative of the regulator like you, Alessandra, and me for competition authority, but also a scholar on this topic. And Chiara may help us to have the view of a regulator, but also of the BEREC, because Chiara is strongly involved in the reflection undertaken, again, sorry for my English, by the BEREC. Chiara, the floor is yours, and thanks for being with us.
Thanks a lot, Frederic. Yes, I will put on both hats of Arcep, so the French regulator, and also of BEREC, which is the European body of all Arcep, so of all national regulators in electronic communications in Europe. And both Arcep and BEREC have been quite actively contributing to the debate on the digital platforms in the last years. And last year, when there was the public consultation of the European Commission on the first projects, which were back then, it was called the DSA package, we also contributed to the public consultation and proposed a framework, a regulatory framework of intervention towards digital platforms. So in general, of course, we are very happy that the proposal is there, and we strongly support the ambition of the European Commission of creating contestable and fair markets, and also because it is, of course, something that it's very close to us, because in the last 20 years it was our job also to open up monopolistic markets to competition, and to create the conditions and lowering barriers to entry for and fair behaviors to make sure that the competition dynamics would be healthy and would work. So as it was mentioned by other speakers as well, we also think that the DMA is a very good first step in the right direction. And then, because when we observe also the evolution of these markets in the last years, we see that there was a need to do something, and it's something which is, I mean, we can observe the same trends also in the US, in the UK, and in some Asian countries, so like South Korea, indeed, as Simonetta mentioned before. And so in a general feedback, maybe feeling on the DMA, on top of the fact that it is a good initiative, is that it is a type of ex-ante intervention that we find a bit peculiar. And I see the point of Alexandre that, of course, when we look back to how the telecom sector was at the end of the 90s, so let's say the regulatory framework back then, the DMA looks more similar to that than to what the telecom regulatory framework is now. And so for us, since we are now in 2021, it was a bit peculiar to see like the choice of the European Commission, of the regulatory framework, which was chosen. And we have the impression it's a mix of ex post competition law enforcement, but applied ex ante. So it's a mix of both, and which can work. Maybe it's a new way for a new digital market. So it's also a new way and new approach. So it's not bad per se. But what we think is that there are some maybe 3 points which would deserve some further thinking or some improvement. And the first one is about the regulatory dialogue. The second one is about the design of the obligations and of the regulatory enforcement. And the third one is more the institutional design of the enforcement, so a bit more the governance. And I will detail further on the three of them. But for us, so it is really like along these 3 lines that the DMA could be improved. So maybe one last point, because then I will, for the details of these 3 points, I will get back to it later on. But maybe on the dynamics of what is happening now, since the other speakers have not focused on it, so maybe I will add a bit on this point, because as Alexandra was saying, actually it will go fast. I agree that it's moving fast. It's happening now. The European Parliament had to publish a report yesterday. It's a bit delayed, but it will come soon anyway. The European, the Council, they also found there is a compromise which was reached recently, and it will probably, so we will probably have a final text adopted by December next year. And maybe to give you some flavor of what we could observe in this EU institutions, so especially on the Parliament, because as BEREC, our role is also to advise the EU institutions on several topics where we have an expertise, and we have engaged with different MEPs and the rapporteur on the DMA recently. And what we see is that there are still 2 main points which are being discussed in the Parliament, where the compromise will have to be reached. On the one hand, we have the scope, and on the other hand, we have the measures. So what are the obligations, how that it would look like. So for the scope, the question is read like, shall we target like more largely, so have more platforms which are targeted by these regulations, or shall we just select a few of them? And on this, our point is that, we see the benefits of real asymmetric regulation. So to focus only on few platforms who are raising the real problems. And why? Because of course there is always a trade-off between the ambition and the target of the regulation. So if we want to be very ambitious, then we have to limit the scope of the regulation, because otherwise the platforms are very diverse, and it will be very hard to have some proportionate and clear obligations which can apply to a range, very large range of digital platforms. So we would rather be for like a smaller scope, and but with a very clear and ambitious obligations. And on the measures, so on these obligations, there is a strong willingness from the Parliament to reinforce some of them. So to, for example, to move, so later on we'll probably talk a bit more about the structure of the DMA, but to move some of the obligations from Article 6 to Article 5, so meaning to make them really self-executing. without further specification. So there is this willingness to reinforce this framework and also to introduce new obligations, like, for instance, interoperability, which is very much now in like the hot topic, so on which services then interoperability should be imposed. But I agree that in general, all the proposals that we have seen so far that maybe can change before it is official, but there is nothing which is like groundbreaking. So I agree with Alexandra that the proposal of the Commission, that it will be refined, but it won't be like a revolution compared to the first proposal. So the proposals of the European Parliament are going, let's say, into the direction of reinforcing and strengthening some obligations, but the framework of these do's and don'ts will probably not change. I think I will stop maybe here for now, and then I will maybe to come later on the details of the 3 points that I raised.
Thanks, Chiara. Perhaps before starting some direct exchange between us, if you want to react on the different points, we have a question on the chat on YouTube by Magali Elben. So Magali has two interconnected questions. The first question of Magali deals with the internal coherence of the DMA, that is to say, the equilibrium between general objective and specific obligations. And the second question of Magali is the capacity of the DMA to make the objectives of the EU competition law clearer. That is to say, if we consider the DMA, is the DMA a chance, in fact, to make the scope and the objectives of competition law more easy to define, or is the dual nature, in fact, of the DMA both regulation in a large extent, as Alexandre has previously defined, but inspired by competition law precedents, if we see the influence of the case law on the DMA, can we have something like a clarification through this point? I do not know who wants to take the floor at first on this point. Simonetta? Simonetta, your mic is cut.
Yes, so perhaps I take the second one. So the relationship between the DMA and the competition policy. So the thing is, in the course of the discussions at the European Parliament, that was one of the most interesting issues as well. And it has emerged also the need to have a framework which allows, I think it's very important to keep it there, that allows for experiments to go on at the national level as well. So one of the experiments we have already is not Article 19A of the German Competition Act, but we have other experiments. I think, for instance, in Greece, the idea of introduce an abuse of power provision for ecosystem with a structural importance is also a very interesting one. So I don't see the DMA as a hindrance to the development of competition policy, perhaps differently from the way we are used to seeing competition policy evolve, because there will be an interesting always interaction between the two, and I think that interesting things can come out of that. Another example, and then of course Alessandra is on the panel and she's an expert on that, but there is also the idea of amending Italian competition law to strengthen the provision for economic dependency in terms of providing, similar to the Belgian legislative amendment. So there are interesting things going on. So I think that the two will evolve in parallel, and perhaps, as Magali was saying, yes, the one will help to clarify the objectives of the other. But I'm very optimistic about the fruitful interaction between the two.
can I just react on that and,
Yes.
and time to some other point? Because I fully agree with Simonetta, what she said. I mean, all of that is still very, very new, you know, and so there is a lot of value in experimenting solutions and testing new things. So it will be very important that the member states are still able to do that. And so this is why myself, I read the DMA as a kind of minimum harmonization. You know, those are the minimum obligation and prohibition that will be applicable all over Europe. But then the member states could go further with their own national competition law, provide, of course, it is respecting the European, that it is in line with what you could do under European law. But so that is very good. My worry is that I don't see a kind of a feedback loop on how those experimentation will be then integrated in the DMA. You know, I think it's very, very good to have those experimentation and to allow those experimentation. But then what is even more important is that the result of those experimentation are brought back in the DMA. Now, one way to do that would be every time there is a revision of the DMA, you will be able to adapt the list of obligation and prohibition according to what has worked in the member states, but let's say that it's not formally done, and that leads me to the point that Chiara was mentioning about the debate in the European Parliament. What worries me sometimes in the debate of the European Parliament is that they want to solve the solution once and for all. You know, they have the impression that, you know, this is the moment to do something and it will never come back. Which is not true. I mean, and again, that is an advantage of the European lawmaking compared to other jurisdictions, is that we will revise the law. I mean, I'm sure that we can take an appointment in 5 years and to discuss the revision of the DMA that the Commission will have put on the table in 5 years. So, you know, I think to take back to the scope, I fully agree with what Chiara is saying. It's better to have a limited scope and to concentrate on where the problems are the most obvious. And then if it works well, then you can extend the scope. So I'm a little bit worried about the proposal in particular by the left of the parliament, which wants to increase the scope, because that will not work. I mean, first, I think that will not work because it will dilute the resources. And also, given the fact that we have to experiment things, it's better to experiment things on the biggest player. I am really a bit worried sometimes when I have this impression that the people wants to solve the thing once and for all. And then to address the question on the objective, I agree that the objective are not maybe very clearly defined. I regret that it doesn't seem that they will be better defined after the legislative process. As Chiara said, I mean, there won't be a big change. But so the role will be in the practice of the Commission and then in the case law to try to help. But I think you can make a connection between an innovation objective and the obligation. It's not sufficiently done, I agree, but I think you can make it, contrary to what other commentators which have said, I mean, this thing will kill innovation in Europe. I have even read that kind of statement, which seems to be at least a bit exaggerate, because we really don't know. But I think you can make a connection between innovation and some obligation.
Excellent, thanks, Alexandre. Perhaps first Chiara and after Alessandra. Chiara?
I will be very short. It's just to build on what Alexandre was saying, because as the regulators, one of the positive things of a regulatory framework is that there is a trial and repeated games. So of course you can try something and then it doesn't work and you come back, and the gatekeeper in this case, or market players in other sectors, they know that you will come back. So they have, of course, they have to reason when they have applying a behavior, they know that it is not just one shot, but that you will come back, you will revise, you get more information, and you will lower the information asymmetries and so on. And I think it is like very important, and also the Commission gets, and also the other institutions, integrate this idea that it is a trial and we are just learning. So you have also to build like the learning tools to get as many information as you need, so that you can adapt your intervention afterwards. So the adaptation and the intervention is also something that should be integrated, because there is nothing wrong actually in changing your previous intervention. It's just the objective, it is what, I mean, you have to reach the objectives and then you can change the tools and adapt them. And it is actually the basics of regulation. So I very much support what Alexandra was saying, and hopefully it will go in this direction.
Yes. A response, perhaps, Alexandre, if you want to add something on this point.
No, I fully agree. Sorry.
Excellent. So, Alessandra?
No, sorry, Alexander, if you first want to react, I'll add later.
No, but then, yes, I fully agree. I think, again, maybe that's not very clear in the text, for instance, to take a specific example, when the Commission has to specify an obligation, to explain more in practice how it will work. It's not clear to me how, if after 1 year the Commission realizes it doesn't work, how it can re-specify. I don't think it is excluded, but it is not organized in the text. But more generally, I fully agree that we are in a repeated game situation, and this is what distinguishes regulation with competition law. And sometimes, and maybe Alessandra, you may react on that, but sometimes, I have the impression that, as Alessandra has mentioned, the debate was started with the antitrust authority, and still the debate is owned by the antitrust community, and they have a very difficulty to leave it to the regulatory community, which I think personally is a mistake, because in general, antitrust authority are not in that repeated game. That's one of the big difference between an antitrust authority and a regulatory authority. Is an antitrust authority is one-shot game in general. Okay, while the antitrust authority is repeated game, and here we are in a repeated game situation. So this is why I think I would be, for instance, worried if it is only DG Com which is in charge of the implementation of the DMA in the Commission, and it's only the National Competition Authority which are in support of the Commission. I think really we are in a regulatory environment, and it should be the regulatory people in charge. But I must say that I am biased because I consider myself more regulatory than antitrust. But I think this issue of repeated game is important.
Yes. Thanks, Alessandra. Last point on this first round with Alessandra.
Yes, no, I also want to react to but the first, maybe because I have a different perspective, also as a practitioner with respect to academics, it is difficult to look at this exercise just as an experiment, because of course we are dealing with new issues, and we are so maybe also experimenting new solution, but in the end you will have to implement these rules, and these rules change a lot the framework for companies. The companies need a certain degree of certainty, even if they are the big platforms, and also the enforcers or the regulators. So, for example, what Simonetta mentioned, that there are also national initiatives, interesting national initiatives taking place, doesn't necessarily add to the clarity of the picture. So sometimes the concern is that we might find ourselves in front of a regulation that are contradictory. We already, the DMA will have to interact with other regulation, or even recently adopted, the P2B regulation. We haven't mentioned there is consumer protection. There are a number of different areas, which leads me to replying also to Alexander. I think probably there is a feeling of ownership from the competition community on this debate. I don't think the right approach would be to deny that we need an interdisciplinary approach to the problems of the digital economy, because there are a number of overlapping issues that require that regulators are involved. But still, maybe I'll say it more on the institutional approach. Sometimes what we are concerned about is that we see this parallel on telecommunication regulation and the digital markets regulation that doesn't completely apply, because in our opinion, because I think that the kind of problems that we approached with regulation in the telecom sector were problems that dealt with players that were very similar, while we are now addressing players that are very different from each other. And also with markets that are, of course, we reason as competition authorities in terms of markets, but still we are discussing the Digital Markets Act that involve a number the issues that we'll see with this regulation will affect not only, for example, advertising markets, markets that are familiar to TLC regulator, but financial markets, and a number energy markets. The Italian Competition Authority closed this year a case related to Google that had to do with the electricity charger for cars. So that was the market that we had to look at. So I think this is this is why the competition authorities think that the competition authorities view maybe has this horizontal aspect that sometimes you don't have with sectoral regulation, and that digital markets are not sectors.
Thanks, Alessandra. Perhaps one word from Simonetta before our second point, but we have already said a lot of things about a third point, so we are on time, in fact. So, Simonetta, the floor is yours.
Yes, thank you so much. I just wanted to say, I totally agree with Alessandra that we have a big issue here, and that is the scope of the different pieces of regulation. We have it increasingly, but I think that's really a general question. When I think also of AI regulation, the proposal, when I think of Data Governance Act, when I think of the upcoming Data Act, this is going to be one of the big issues. And I have the impression that the Commission thinks, well, yes, it's possible to make the difference here. Okay, you can really walk on a very thin line. But no, I think we will need much clarity for companies, for everybody, I mean, for the academia as well, to really understand which is the scope of the different pieces of this big digital puzzle in front of us.
Thanks, Simonetta. Perhaps for the second round, I can leave the floor to Laura.
Yes, thank you. Thank you very much, Fred. I completely agree with you that we already started the second round, and we also started the third one, because thanks to your comments and thanks to Magali's questions, which were really on point, we already opened the debate. So my idea would be maybe to give you the opportunity to share a few more insights linked indeed to the text of the DMA, thinking about what is in the text that you think should be changed, what is in the text that should stay as it is, and what is missing in your opinion. So we will mainly focus on the scope of the DMA and the mechanism that the DMA is activating, different indeed to those already enforced in the competition policy or in the previous pieces of regulation. So I will maybe give the floor to Simonetta first. If you want to add a few points on what, in your opinion, maybe is missing from this DMA, or what indeed should be removed, changed when it comes to the scope and the purpose of the draft.
So thank you so much, Laura. It's almost an impossible question because it really depends on the text that you are looking at, because we have seen so many different versions, of course, of the DMA, also because of the rapporteur, etc., inco-rapporteur, etc. So I'm trying to focus on what we have heard about a possible possible amendments the European Parliament might agree on. So that would be the last stage. So not so much the Council proposal, Council version which has been circulating, which is, I would say, a little bit too conservative in terms of things that could have been changed. So looking at the current discussions at the level of the European Parliament, as I said, I think there have been interesting improvements, especially with regard to the different obligations that we had as proposed by the Commission. For instance, the interoperability provision has been strengthened, which I think is helpful because it starts covering some core platform services, not only ancillary ones. And then there have been some also interesting ways of framing the different obligations in ways which make the different obligations clearer. Okay, so that's one of the things we want to have them applicable by design, so they should be clear enough. So there have been some, for instance, with regard to the one of the obligation related to data. So if you want to combine data from third parties with data from your core platform services, and you need to have explicit consent. One of the questions is why hadn't we gone beyond that? I mean, that was the legacy of competition enforcement. Perhaps looking at the Facebook case, it's one of the things perhaps we could have gone a little bit further. What I've been missing since the very beginning in this DMA proposal was something that hasn't been touched upon. So the idea of more coordination. So on one side competition authorities, on the other side data protection authorities, on the other side telecom regulators, etc. That has not materialized in the way which I would have hoped for. I would like to see more cooperation by way of an institution there. I would like to see also more focus on future-proofing the DMA, which is there. I think it's not strong enough. Things should be much quicker in case you need to update it. And the other thing, I would really like to see interim measures, which are possible, but not only interim measures with regard to obligations we have already, but also with regard to new types of unfair practices that are not in the DMA yet. So interim measures strengthen also in that respect. I would like to see much more in terms of compliance as well. So I would like to have really somebody at each of the platforms in scope of the DMA, compliance officer there embedded, and then reporting to the European Commission. So I think many things in terms of compliance could have been done perhaps a little bit better. But then, and then something which I would have very much liked to see would have been something like users panels as new types of institutions. So a stronger role by users of the platforms in terms of governance and things like that. So represented in some form, and being able, not by way of consumer representatives, but themselves as users, I don't know, Amazon users, being able to have a dialogue with the European Commission as well. So those are basically the main areas, but I think, as I said, I'm thinking we are moving in the right direction somehow.
So thank you very much, Simonetta. Yes, I think, all the comments you made are perfectly in line with this general necessity of having a draft which in the future will be still valid and will be able to evolve and to take into account all new conducts that we may experience. And I think this is very also much linked to the comments, Alexandra, but you all made on the need of kind of maybe limiting the scope right now and then enlarging it on a later stage, because otherwise we risk not to have a piece of regulation which will be enforceable, let's say. So thank you very, very much. So I don't know, Alexandra, do you want maybe to complete or add elements from the perspective, from your perspective when it comes to what is in the draft, I mean, it's not easy because we have a lot of them, but what are, let's say, the major strengths and weaknesses, or if you have further points, because I think the second round will indeed evolve in a more spontaneous way, because you already shared a lot of the points concerning the scope and the purposes.
Yeah, so I think I want to make maybe two points. One is on the obligation and prohibition, and one is on the merger that was mentioned a little bit before. On the obligation and the prohibition, so I mean, just we have to understand where we are. So this is a text where there is 18 relatively precise obligation and prohibition, which some of them will apply to every platform, so to every business models. Others will be business model specifics. I think it's important to say that because sometimes I read some commentators which are criticizing the text as saying, okay, it's not good because the 18 obligation will apply independently of the business model. That's not correct. I mean, maybe half of them will apply to every business model, but the other half are business model specific, okay? And I think it's good. It's good to say that because indeed, I agree with the fact that some obligation needs to be business model specific, but I disagree with the statement which is saying that this is completely ignored by the DMA. So it's relatively detailed, and you know, if you compare to other initiatives in the world, in the EU and elsewhere, in general, they tend to be more based on standard and not so much on detailed rule. You know, if you go to the German competition law reform, which is addressing big tech to some extent, if you go to what the UK has in mind, if you go to what the US has, what has been proposed in the US Congress, those are each time much more general and more flexible rule. But as we discussed already, I'm not sure that the choice of the EU is bad when you start with, because it has the advantage compared to all the others initiatives to be easier to enforce. So I think, provided that you don't remain stuck with rigid rule, but I think that to start with rigid rule is not necessarily a bad choice. One thing which is, however, missing, or two things which are missing in this rule issue is one, that, and it has been mentioned by Simonetta and others, that maybe next to those detailed rules, we need one more general rule, which is around interoperability, because clearly interoperability is the key stuff, and Chiara has mentioned that as well, and I think Berek has pushed that as well. Interoperability is absolutely key here, and so we have some specific interoperability obligation, but what I would have liked, and I still hope, I'm still hopeful, although I don't know how the debate will evolve, but if there is one thing to add, it would be, I think, an interoperability obligation, a more general interoperability obligation, you know, because this is how you create level playing field and equality of chance in those markets, you know. I fully agree with Alessandra that it's we are in a different environment than telecom, so that's very true, but if there is one commonality, probably with telecom, is on interoperability. Okay, so this is what is missing, and the other thing which is missing, and this building on what Simonetta was saying before, is that how you can have a feedback loop where you integrate what you learn from experience, what the Commission learned from experience in its own enforcement, and what the member states learn from experience in their own enforcement. I think those are the two things which are missing: interoperability and feedback or learning from experience. Now, going to the second point, which is about a merger, this is really the missing piece. You know, the DMA do not address merger. I mean, there is a very small provision to say that we do something, but it will be extremely weak, which consists of obliging the gatekeeper to give information on merger, on the small tech or start tech acquisition that they want to do, but they don't really go further than that. Now, this is striking because if you go to the economic literature, they are telling you that, but I mean, Fred, you are there, so you may confirm or not, but that really this is a key stuff. You know, if you want to alleviate the problem, you need to have a stricter merger control. Or stricter, or at least a different merger control. Now, the Commission doesn't want to do anything about it, and I don't know why. I mean, we should ask them. But my perception is that first they think there is a legal issue there, because they say if you want to change the merger control regulation, which is, you know, the rule on merger, you need unanimity. Now, here I disagree. I think you can change the merger regulation with qualified majority. We have published a legal opinion on that, but I would not bore you with the detail, but just to say that this can be discussed. But even if you don't want to change the merger regulation, which is the hard law, I think you can do a lot by changing the guidelines. And this is in fact what the US is about to do by revising the merger guidelines. So I think the Commission could open a revision of in particular, the non-horizontal merger guidelines, and say that they will approach conglomerate merger, because very often those kind of type of big tech acquisition which may cause a problem are some form of conglomerate merger, that they would address it differently. So I think that the legal point is not valid. So maybe there is another reason, is that the merger people tends to be conservative, and indeed they tend to be, and so they don't want to change their system. But you know, we have a kind of catch-22 problem, because the merger people say we apply guidelines, and they also say we only change guideline when we have new case, because guidelines are supposed to codify the case. But you know, if they in every new case they apply the guidelines, nothing will ever change. You know, it's a bit the same problem with AI. You know, AI tend to reproduce the past, but not to invent the future. And so we have a big problem here, that we are stuck with those guidelines, and that it seems that sometimes the Commission is innovative. And with Down Dupont, they have been, but you know, and it was, I think, Valetti pushed a lot for it, but otherwise they tend to be relatively conservative. So that I am a bit worried, because what will happen? I mean, the member states, Frederic, you have mentioned that the member states push for it. I don't think they will just wait for the Commission changing. I mean, if the Commission doesn't change, the member states will take the issue themselves, you know. And what will happen is that a kind of a merger control which is disharmonized for global platform, I mean, which is completely paradoxical, you know. So, you know, really next to this DMA, we need, I mean, the Commission needs to push this merger chantier, I would say. Otherwise, I fear that the member states will take over, and that would be the worst for everyone.
Thank you very much, Alex. Yes, indeed, I think the elephant in the room is this complete absence of rules on merger control. And I will not take time, because I think we need to focus. So connected to this need of a more general interoperability obligation that both Alexandra and Simonetta stressed, but also previously comparing with the telecom regulation, I think that maybe, Chiara, can you give us a few insights from your perspective on what can be taken? Maybe, I mean, we already quickly framed this, but what would you maybe change also in light of your experience in the telecom sector?
Yes, thanks a lot, Laura. So maybe just one first reaction on the fact that we hear a lot that telecom regulation, of course, is very different and so on. And as telco regulators, we do not want, I mean, we never thought that we should just take what we have now and just transpose it to digital platforms, of course. So we see that they would not work. But what we think that would work would be to take the tools and the principles actually behind the regulation of electronic communications, and some of these tools and these principles can also work for digital platforms, and interoperability is the typical example from the technical point of view. And also the other point which is often raised is that telecom markets, it's homogeneous, then the players are always the same, are well known and so on, and so it's very different from digital platforms. And I think what is interesting in this point is that actually, so we say this, and on the other hand, we have the DMA, which is much more homogeneous actually with the obligations that are imposed than what we do in the telco sector. So in the telecom sector, we actually have much more flexibility to adapt our remedies than what is foreseen now in the DMA. So it is interesting to see that on one hand, we say we cannot take the principles of electronic communication regulations because it's too homogeneous. And on the other hand, we have 18 obligations which are written in the law and expected to be self-executing. So it's I think there is actually a way a bit in the middle that can be found. So we'll list what I think is missing in the DMA, which is based on our experience as regulators, and I think that it's quite at the end it's actually both feasible and it would not really change the logic of the DMA. So the first one, so it's mainly 3 points, but probably just 2. So the first one is about the regulatory dialogue. The second is the remedy tailoring. And the third one is about the institutional design, but we can discuss it maybe in the next round. So for the regulatory dialogue, so now in the DMA, we have these obligations, and some of them are susceptible to be further specified. And this can be done in the context of a regulatory dialogue, it is called, with the gatekeepers, between the gatekeepers and the European Commission. And as ex-ante regulators, what we saw is that for some measures, especially when they are highly technical, they will not be effective if they are not correctly specified. And to correctly specify an obligation, you cannot just ask the gatekeeper, but you need to ask actually the other parties, third parties like business users, potential competitors, or even end users. Because actually the gatekeepers has really no incentive to lower the information asymmetries with the regulator. So if it is just asking the gatekeepers how we want the obligations to be imposed on it, it is likely that we will not really get the full picture. And this can actually be done in a, I mean, I understand the European Commission always replies on this, that they want to avoid bothersome discussions with the gatekeepers, and I think it is sensible. I mean, it can be understandable. But there is also a way to involve third parties without having like bothersome discussion. So for instance, when you ask the gatekeepers to propose the implementation of an obligation, these concrete proposals could be open to public consultation, and third parties could be asked to react on these proposals so that you get actually information from the market players. And it is easier then for European Commission to specify the obligations together with the concerned parties. And another point that is always raised when we propose this regulatory dialogue is that it would take time. And actually, I think it is also important to see what we call a swift intervention, because for us, what is swift, it doesn't mean that you have to intervene quickly. It means that you want to reach the results quickly, so in a short time frame. And in order to reach the results, you need to specify the obligations in a good way. Otherwise, you will have to intervene ex post because it did not work. So the first one is the regulatory dialogue, and the second one is the design of the enforcement, so the design of the measures. So now we have this list of do's and don'ts, which, as we said, is mostly based on some previous antitrust cases. But while in ex-ante regulation, we are more used at identifying the structural issues and then designing the obligations and remedies accordingly. And we understand also, I mean, the rationale of the European Commission of this obligation. So I think it is good. It's a good starting point, as Alexandra was saying. It's good to start like this because we don't have many, I mean, we don't have the knowledge yet. So it's good to have these clear obligations. But we also think that on top of this framework of obligations, so not replacing it, but on top of it, we could also have another article giving some powers to the European Commission right away, saying that when the risks of the harmful behaviors are not effectively addressed by the obligations which are in Article 5 and 6, and also for more technical remedies, like for instance, interoperability, then it would be important to have like the possibility of tailor some remedies. So there would be, for example, there would be in the law, there would be some ex-ante principles, and then a list of remedies, which can be interoperability, access, non-discrimination, and so on. And it could be, they would be tailored according to the to an analysis, an assessment which would be done by the Commission. And this would be on top, actually. So there would be the obligations, and if they don't work, then the Commission has already the tools and the principles to adopt other remedies. And this is something which is done in the telecom regulation. That's how it is structured, and something so that it would not raise issues of legal certainty, because it's actually something which already exists. And it was also something which was present actually in one of the first leaked version of the proposals by the European Parliament some months ago, but then which disappeared. So it's something that was a bit in the debate for a moment, but then now it's probably staying. What we will have at the end was probably just this framework of these 18 obligations. And then on the institutional design, I will keep it for later probably.
Great, thank you very much, Chiara. Yes, I mean, I really like the idea of reacting to the objection that, honestly, I consider myself a competition law scholar. We use to always say that telecom is not an appropriate model, but it's nice to see that we can read the DMA as something that is very far and even more, let's say, strict and less flexible than the model. So, and of course, the lack of a regulatory dialogue and the need of tailoring remedies are all linked to this idea of having a regulation which is more future-proof, because indeed we risk of having a system that will reveal several weaknesses and will not be ready to, you know, evolve in a way that can be applicable and effective. So I would kindly ask Alessandra, considering her expertise from the point of view of competition assessment, competition analysis, if she can share with us her insight on this second point.
Thank you, Laura. I think hearing what Chiara was saying with respect to the objections to extending the regulatory dialogue are very similar to the objections some of the competition authorities or people from the competition community heard when they proposed to take into account efficiencies. So the idea is behind the DMA is clearly to have an instrument which doesn't require a lot of individual assessment. To be honest, I'm quite pessimistic about the instrument being successful in this. Because, well, first of all, you have already a lot of obligation, and we risk at the end of the parliamentary discussion maybe to having more, which I hope it's not the outcome that we have. But then again, the idea that these obligations are self-executing. If you look at them, today I was reading them again in preparation of this, and some of them really in practice are the text is not very clear, but in practice they are not very clear. When you say self-preferencing can in practice be a number of different, it can take a number of different forms. It can be in the forms of a refusal to deal, in the forms of tying, in the form, in innumerable. And what we also fear, and the competition authorities has stated that in the ECN paper, is also that the companies will adapt very, very quickly in maybe finding different ways to do the same things. So I think that we would much rather, but I don't think we are going in that direction from the discussion, on having some principles. In this respect, I feel that, for example, the German law would be more effective, because you will have to do some form of individual assessment. It is unescapable that there will be some form of individual assessment if the specific company is complying with the specific obligation. And this will not be as easy as I think the idea behind having this list is. So maybe one idea that I've seen a proposition is at least to group the different conduct under you know, the different umbrellas of principles, what you are trying to obtain. And this might maybe make it work in better. But so this was the other thing. I largely agree on the problem of the scope with respect to who the gatekeepers will be. I think here in the discussion we heard different numbers while we were discussing, going from the 15 gatekeepers listed in the impact mentioned as a likely number in the impact assessment. When discussing this, instead, many people who are commenting think that this will focus only on the big on the GAFAM to be clear. I think for the reason that others have mentioned, that it would be better to be focused, because if we add other gatekeepers to this list, it will be even more difficult to implement the DMA. And finally, yes, on the merger, this is obviously, as I said at the beginning, a big gap that the DMA is not addressing. While from the discussion, and I'm saying this as an economist, I think this is probably in the merger review is where we might be more effective in acting before we find ourselves in front of platforms that then occupy a position in the market that becomes difficult to break. So this is and this well, it would deserve a different discussion, but I think the reason that Alexandre said, there are legal reasons for not intervening, but there are lots of political reasons also, and the issue of European champions is probably one of the reasons why the Commission doesn't want to open the Pandora box of reviewing the merger regulation. Thanks.
Thanks, Alessandra. Perhaps tempus fugit, as we say, not in English but in Latin. We should make a turn around in this round table for perhaps 2 minutes each, no more, on institutional features. That is to say, what we could add in an optimal situation. If we could complete by some proposals, the DMA, or to imagine a perfect institutional configurations. We can consider these points for 2 minutes each. It is a challenge. It is, I think, impossible to do, but we can try. And after, we can pass to some words or some sentences of conclusion from Laura. Alexandre, if you want to put into relief one or 2 points, perhaps 3 if you want.
I'm not sure whether you said Alexandre or Alessandra.
I said Alexandre, but Alexandre and Alessandra is the same thing, in fact. So Alessandra, if you want, you can.
I didn't want to cut Alexandra, but I saw that he also was unsure. But I'll try to be very quick on this, because I think we touch upon also in speaking about the other points, we also touch upon the institutional framework. The DMA makes a choice of centralization, a clear choice for the Commission to be the sole enforcers. There might be good reason for this, because of course we are dealing with platforms that play a role throughout different national markets. Sometimes, even as competition authorities in doing the cases, we are dealing with something we start on a national level, but then we realize that the problem is a problem that affects different national territory. So what the point that the competition authorities made in the ECN paper was for the reason that we discussed extensively, that it will be very difficult for the European Commission to implement the regulation as it stands by itself. So the idea was, why don't we try to go to a model where we have joint enforcement? And the argument was, it was something that worked very well for competition enforcement in the framework of Regulation 1/2003. Some others, there was the proposal by Germany, France, and the Netherlands proposing a system closer to the merger regulation with a system of referrals. So on this, at least on the side of the Council, is where we see some change. Maybe not exactly what the competition authorities had advocated, but at least recognizing a power of investigation also for the member states, and in particular for the competition authorities, and also mentioning the European Competition Network as the place where coordination could happen, because it's been successful for at least successful enough for competition law. So I stop here.
Thanks, Alessandra. Now, Alexandre.
Okay, thank you. So, I mean, I think there is two main points. One is centralization is a good thing, because we are talking about a big firm which have a cross-border operation. So we don't repeat the same mistake as with the GDPR, where we think that the Irish Data Protection Authority will have the ability and the incentive to regulate for whole Europe. So that's good. But that means that the Commission will have now different power. I mean, we'll have the antitrust power, we'll have the DMA power, and then also the DSA power. And what I missed is how the synergies between those different power will be maximized. Because clearly, I mean, there are some synergies. We are talking about the same firm, the same algorithm, the same data sets. For different issue, but those are the same object, let's say, of regulation. And so I think, for instance, the Commission should more clearly explain in which case they will use which power, or the information exchange should be organized. So if the Commission gets some information under the DMA investigation, how far that could be used for an antitrust case, for instance. So that's one thing, to maximize the synergies of the different power that the Commission have. The second thing is that, and we have discussed that already, the regulation needs to be participatory. Otherwise it will not work. And I fear that on that, the DMA is not very good. I mean, the DSA, however, is much better. It is really involving the user of the platform, the national authorities, the civil society, and the vetted researcher, for instance, to analyze data. I fear that the DMA is too much modeled on an antitrust approach, which is a bilateral relationship, and that will not work here. So we really need, and it's good that the Council text goes in that direction, but I think not enough. We need to have a participatory approach to regulation here.
Excellent. Thanks, Alexandre. Chiara, perhaps some words about the perspectives in an ideal world.
Yes, I will focus also on 2 points. So the role of the national authorities and also the interplay with other regulatory frameworks, which could be overlapping potentially with the DMA. On the first point, since Alessandra was mentioning the position of the Council, so then I will support the position of the European Parliament so that we are neutral at the end. So in the European Parliament, there was this proposal by the rapporteur Schwab to create a European high-level group of digital regulators. And it's something that BEREC was proposing from like the very beginning, from last year. And it's something that we believe is it makes sense, because I totally agree with Alexandre that the intervention has to be at the EU level. There is no question on that, because of course it's the only way to have something which is consistent, and also to take account of the scope of these platforms. But at the same time, it's also true that there is some relevant expertise at the national level, ex-ante expertise, competition law expertise, which has been developed in the last years, and it would be a pity actually not to rely on this. So what we think is that there are some national authorities which have the advantage of being in constant interactions with the national players, national users, and who have experience in monitoring markets, monitoring innovations, and or experiencing ex-ante regulatory enforcement. So we believe that together with what is foreseen now in the DMA, which is the European Commission plus this DMA committee, which is more following the comitology procedure. So it means that will be more political actually body rather than like a neutral board. What we think is that we should complement this framework with also another body, an advisory body, which would be made of competent authorities at the national level with relevant expertise. So it would be the ex-ante regulators of the communication sectors, the national competition authorities, the data protection authorities, and this advisory body would be in charge of advising the European institutions, so the commissions, but also the other institutions like BEREC does as well, make recommendations, providing this technical and neutral expertise. But it can also be like very technical, or practical, let's say, tasks like data collection, for instance. It could be data could be collected in an harmonized way. It's what we do in BEREC as well. It is national authorities collecting the data from the national players, but then it is done in a harmonized and homogeneous way so that it can be used at the European level as well. So it wouldn't be like about delegating powers. It would be just relying on existing expertise actually, but then taken at the European level for the enforcement. And it could be also, the national level could also be done the monitoring of the compliance with the obligations. So, with this idea that it's closer, the authorities are closer to the market players, to the national market players, and can follow this better. And this idea of putting together also different expertise is not something completely like out of the blue and something new. It is something which is also supported by other initiatives, like in the UK. It's more in this idea of putting together more interdisciplinary expertise. So this is my first point about the role of national authorities that I think can be integrated even with the idea of keeping a centralized model. And the second one is about maybe the interplay with other legislations, because we have been discussing a lot, it's been like the hot topic on how this DMA would interact and what would be the interplay with competition law enforcement. But then on the other hand, it's actually also other regulatory framework who are applying actually provisions on services which are part of the DMA as well. And one example is the number independent interpersonal communication services known as NICs, so like WhatsApp or Facebook's Messenger or others. And these services, they are already regulated under the European Code of Electronic Communication. So it will be important, especially seeing how the discussion are evolving in the European Parliament, where they want to create some interoperability measures for this kind of services. In that case, then it will be fundamental actually to have some cooperation mechanisms with the relevant regulators. Otherwise, we would both be applying and imposing measures on the same services, which is not necessarily very good. Without coordination, then wouldn't be very good for legal certainty. So these are my two key points.
Many thanks, Chiara. So Simonetta, perhaps some final points on your side?
So, thank you. Well, I don't have much to add to the very nice ideas, those proposals put forth by my previous panelists here in our conversation. Perhaps 2 points. First of all, we are here regulating digital gatekeepers, but in an ideal world, I wouldn't want digital gatekeepers. So that brings us back perhaps to your point at the very beginning about structural remedies, which are really not on the table anymore, and I think it's a pity. And I think we are spending really quite a lot of time on regulating those basically GAFA, and it could even be a distraction for our more general debate we should be having on digital competition and really digital competition policies fit for our purpose in a world in which we don't want to have gatekeepers. Okay, so it's to some extent, I also see the DMA a little bit of a distraction at this point. Of course, there is the revision of the competition policy framework, which is already there, and the Commission is, of course, very active on that, but we should be discussing it as well. So that would be my last point. Thank you.
Thank you very much, all. I think, I want to thank Eduardo, Vinicius, and IBCI for this excellent opportunity, and you all for this very vibrant and challenging discussion, which is very much needed. I will just take 2 minutes to draw a few conclusions. My impression by our panel is that none of you would consider that it was better not to have such a piece of regulation at all, which is already a very interesting result, because we could also consider the contrary. And I really appreciate the definition you provide us with, which indeed reconduct all the draft to the definition that Alex gave as the very start, which is a revolution based on tradition, because I think we have, let's say, frame very different profiles, which some of them are perfectly in line with the EU traditional strategies, and some of them are indeed disruptive. And I think one of the major concerns, or better, one of the points you draw the attention more is indeed the role of authorities and the concerns we all have when it comes to the enforcement by the Commission, and when it comes to the, let's say, scope of the proposal and the need to have a proposal which indeed will resist all the revolutions and all the new, let's say, challenges we will face. And of course, this is also a matter of resources when it comes to enforcing power. And generally speaking, there is this need of involving all the concerned authorities. So we have seen together both the internal coherency of the draft and the complexity, and let's say the external coherency when it comes to linking the DMA to other pieces of regulation, linking the DMA to competition policy, and linking the DMA also to, let's say, national and risk of, let's say, disharmonization from the national level, as for make an example, the case of merger control. And I think we join a few common understanding also in the need of a more general obligation when it comes to interoperability, so on and so forth. Since we have just 1 minute, I want to thank you very much, you all, for this excellent discussion. I really enjoyed it. I really learned a lot. So thank you. I hope we will have further opportunity to discuss these and future topics of relevance for our community. I think this was also very relevant for our Brazilian audience, even though I agree with the comments. I think, Simonetta, you made, I don't remember if it was you, that maybe it's not as scalable as GDPR, but still is extremely important and relevant at the worldwide level. So I hope you all enjoyed the discussion also outside the EU system. I don't know, Eduardo, if you want to say a few words on the name of IBCI. Otherwise, again, congratulations on the discussion. And thank you very much for accepting our invitation and for sharing with us. This is very interesting.
Eduardo, perhaps you want to add something?
Yes, exactly. Since you are our IBCI director, so if you want to just conclude.
No, actually, I just want to thank you very much, Chiara, Alessandra, Simonetta, Alexandre, Fred, and Laura, and Alexandra Tonazzi. It was a great honor to us to have you in our panel. I must say that this discussion is very important to Brazil, really, really important, involving DMA, DSA, the GDPR, and so forth and so on. I followed the whole panel. Fantastic. Congratulations. And I hope to see you soon in another panel, and fortunately in person. Thank you.
Thank you, Eduardo.
Bye-bye.
Goodbye.
Thank you.
Bye.
Thank you so much to you. Bye-bye.